Swayam Prabha. Digital India. Educated India.
Some of the important directive principles of state policy are what we call as DPSP. As I told you, are say, for example, we are talking of uh, the constitutional mandate to provide equal justice and equal access to justice. In India, a lot of people are not aware of how to get their right redressed. They do not know what happens in case the state or any other person has infringed their rights. And these are impoverished communities, people who are from the economically weaker sections of the community or socially backward. And you will notice that the Constitution of India does recognize that the access to the court or the access to justice must be equal for every Indian citizen. And to further this kind of an aim, we have an article called Article 39A, under which legal aid now has become a constitutional right. So, what is legal aid, friends? Legal aid, friends, is usually where suppose a person who has been arrested uh, doesn't know that he can seek bail, or a person who has been accused of an offense is to be represented before the court of law to prove his innocence or to justify his cause. Then you will notice that legal aid will be provided, and it is the courts that have established what is known as the National Legal Services Authority at the national level. There is a state legal services authority at the state level, and then there is district legal services authority as well. So this kind of arrangement through the legal services authority, legal services to those who require legal services. So there is, for example, anyone who has less than 1 lakh income per year can straight away go to the legal services authority and seek legal aid. And free lawyers will be given, and the lawyer will be paid by the state. So the poor and the disadvantaged community will have the right of representation before the court of law, and their plight will be heard by the court. And that's how the importance of legal aid comes into picture. Usually, legal aid is a matter of guaranteed right to all accused in criminal cases. However, this income that I just said, less than 1 lakh, may be applicable to civil cases, like say those with very minor matters, land litigation, so on and so forth. So this is probably a very important component of our democracy, that someone should have the right to free and fair trial. Someone should have the right to legal aid. Legal aid, I think, like any other aid, like say, for example, you can compare it with medical aid, is a matter of right, and it is the responsibility of the state to provide such kind of aid to those who cannot afford it, one, or those who cannot access the same. So, Hussain Ara cartoon versus State of Bihar is a very interesting case in which, for the first time, the Supreme Court highlighted the plight of under trials. You know that the Supreme Court time and again has asked the jail authorities to speed up the cases of under trials so that they can seek bail. Under trials are those kinds of prisoners who are in jail without getting bail. So their conviction or guilt has not been proved, but yet they languish in jail for a number of years because they do not have the right to legal representation. State of Maharashtra versus Manu Bhai Wasi. This is also an important case where the directions were provided to the states to provide legal aid in all criminal cases, regardless of their economic status. A.R. Antule versus R.S. Nayak also is a very famous case in the same matter, right? So these are some of the very important DPSPs, which I can say very confidently have seen the light of the day. They have been implemented not only at the national level but also at the state level. So while we will definitely discuss which are those DPSCs that have not been implemented and what are the reasons why they have not been implemented. Legal aid, as a matter of as a matter of very important priority. Also, thanks to the cooperation of the executive and the judiciary, this has become a full-fledged reality in the country. And please note, legal aid was not part of the original constitution, as I said you earlier. It was amended and brought in to DPSC, and the states have probably achieved a great degree of success in providing legal aid. Article 39 of DPSC, according to me, is a very, very important fundamental, I must say, direction. This one article in 6 parts talks many things about social and economic justice. For example, what does this say? It says that the state shall direct all its policies in securing the following objectives. Right? So your policies must achieve the following objectives. What are they? That men and women shall be treated equally, and there is a right to adequate means of livelihood. So in India, I think in terms of gender equality, the constitution itself is the driving force. And today, men and women are treated equally, so no discrimination on the ground of sex. This means that the state must have its policy not only vis-a-vis its own state employment, but also in private employment. The state must derive that kind of a policy. 39B, the ownership and control of material resources of the community are so distributed as to best subserve the common good. So all material resources of the community are to be distributed equally for the common good of the community. The operation of the economic system, see, this is very important, corporate, economic, business, growth, does not result in the concentration of wealth and means of production to the common detriment. That means against common good, there cannot be concentration of wealth or means of production. So you can't just have a kind of a monopoly granted to certain companies or to certain industries so that they can make advantage of the entire system. So having a healthy competition or having a law that promotes and protects competition was the duty of the state under Article 39, and that's why maybe the central government enacted the Competition Act as well. Other things I have already said, what is there in Article 39, but I believe that 39 is also an important directive principle that has been put across as the aim and purpose of the state policies. There are quite a number of cases on directive principles of state policy. People have asked why there is discrimination against the state. And for example, in the Indian Express case, one issue that I can tell you is that, newspapers, they wanted newsprint and the state must supply the same. And I think newspapers do serve the common good. They serve the common interest of the community by giving them information, by bringing in some accountability of the government. So their rights on the constitution also is something that the state must intend to protect at all given points of time. Now, Article 41 again is about things like the welfare idea of the state, unemployment benefits, disability pension, medical assistance, all have been introduced by the state to actually promote the welfare agenda, if I can say so. Now, in cases like Olga Tellis versus Bombay Municipal Corporation, the Supreme Court said that the right to means of livelihood of even street vendors is a right that has to be protected. Right. So the government has an obligation to provide some kind of a social security and secure the means of livelihood even among those who may be street vendors or those who trade on footpaths and those who sell food. So we have a separate legislation which talks about such kind of licensing to street vendors as well. So I think protecting people from unemployment, protecting the vulnerable sections of the community like elderly citizens. We have a legislation now which gives protection to elderly citizens. It is called the Elderly Citizens Maintenance Act. Sickness, disablement. So insurance policies have really now, there are several insurances, not only health, but your insurance for crops, your insurance against industrial accidents. I think all of these, in some sense, fulfills the mandate under Article 41. So These are very successful DPSCs that you see here, and they have been implemented in letter and spirit as well. Of course, 45 provision for early childhood care education. It's not no longer just below age of 6 years. It is now 14 years as elementary education as a fundamental right. So the 86th Amendment, I think, was an important one that brought education as a fundamental right under Article 21A right now. So Article 51AK is also core and important friends here. Uh, Please note a new fundamental duty is whoever is a parent or a guardian of a child has the duty to provide opportunities of education to a child, and that is a duty that is there under Article 51AK. Okay, so it's not only the duty of the state, but it's also the duty of parents and guardians, as the case may be. These are some of the cases under right to education, Mummy Krishnan and Mohini Jain. This was time when the state alone was providing education. It was subsidized education, and hence the Supreme Court did not want education to be like a business. It did not want a capitation fee. It wanted to reiterate the purpose of the state, that the state must provide education at affordable prices. Quality education must also be provided. In some cases, it should be free and compulsory. So the responsibility of the government in providing education was reiterated in some of these cases. Now, coming to the direct principles of state policy and fundamental rights. Now, this is a very interesting, what I must say, comparison. As I told you, directive principles are not enforceable or binding. They cannot be justiciable. But sometimes, you use, the courts to bring in or enforce your DPSC. So, the fundamental rights have always been justiciable, and directive principles, on the other hand, are non-justiciable. So they are basically guiding principles. As I told you, these are higher moral norms of the state, and usually you would notice that the Supreme Court, whenever there is a conflict between fundamental rights and directive principles of state policy, have always said that the fundamental rights will prevail because they are core if there is a conflict, right? In a very famous case called Champaka Dore Rajan, uh, that is a very, very important case. I'll just tell you. Champaka Dore Rajan versus the state of Madras. It's a 1951 judgment. The Supreme Court gave fundamental rights an upper hand over DPSC, and it held that though fundamental rights can be amended by the Parliament by bringing some constitutional amendment, this case of Champaka Dorajarajan was overruled by a case called Golaknath uh, case. Now, the Golaknath case versus State of Punjab, it's 1967. So, in 1951, where Champaka Dorarajan said fundamental rights can be amended by the Parliament has all the freedom to do it, and hence few fundamental rights underwent constitutional amendments in the early stages, right from the First Amendment in 1951 to the 17th Amendment in 1964, till the time Golaknath versus State of Punjab came in, and the Supreme Court then ruled that look, Parliament cannot take away or abridge any of the fundamental rights. So fundamental rights are sacrosanct in nature, right? In the words of the court, they said that fundamental rights cannot be amended uh, for the implementation of directive principles of state policy. The fundamental rights are core. You can't change it. So just to implement directive principles, you can't bring in any change in the fundamental rights. So, the Goloknath case, created some kind of a difficulty. And you will notice following the Goloknath case, the parliament wanted to change the power or abridge some of the fundamental rights. And they said, look, for example, if we want to implement equal pay for equal work, then we may have to take away some kind of a right that is there in Article 14, or amend some right in Article 31, a right to property. Now, because the parliament was meddling with the Goloknath case, came in the 1973 Keshananda Bharati case, which the Supreme Court declared that there is something called the basic structure of the Constitution, and basic structure of the Constitution cannot be amended at all. And fundamental rights come within the basic structure of the Constitution, and that is the present position that fundamental rights gain supremacy over directive principles of state policy. And in the garb of implementing directive principles of state policy, the parliament or the government cannot abridge or infringe any of the fundamental rights. So please note, directive principles of state policy ought to be implemented without changing or altering the basic structure of the Constitution, and they cannot in any sense abridge, amend, alter fundamental rights. So I think this very clearly was the direction given by the courts in reading the Constitution. So Part 3 prevails over Part 4, that is fundamental rights prevails over DPSC. Right. So going to the fact that one always wants the implementation of social reforms. DPSC is a social reform agenda. One will definitely appreciate the same. It also brings about what I call the socio-economic justice dimension, but that itself should not result in violation of fundamental rights. For example, I can just tell you that DPSC's kind of agenda of saying, look, let us abolish the zamindari system, the jagirs or the inamdars. We wanted tenancy reforms. We wanted surplus land to be redistributed, so land to the tiller of the soil. We wanted cooperative farming. So all of these agendas were very important. They were part of the social reform that the Constitution wanted the governments to undertake. However, while gaining any of these aims, if these violate the fundamental rights of citizens, which I think prominently was right to property, then that would violate the basic features and the basic structure of the Constitution. Now, just to compare, one second, let me just go back to one more slide that I have. This is the one, right? So, if you compare fundamental rights and directive principles of state policy, let us just understand this in this context. So, fundamental rights are stating what the state shall not do with your rights. They say, please don't infringe speech, expression, right to life, etc., etc. Whereas directive principles are usually positive assertion of duties towards the state. So that is how one will want to compare these two. Fundamental rights are justiciable; they are legally enforceable by the courts of law in case of violation, whereas DPSCs are not legally enforceable by the courts. Fundamental rights aim to establish political democracy in our country. And what does DPSC do? It tries to establish the socio-economic democracy of the country. I think this is quite interesting to note. Fundamental rights is the political democracy. DPSC, the social-economic democracy, right? Because here is all about the political rights of the citizens. I can say civil and political rights of the citizen vis-a-vis the state. Of course, fundamental rights have legal sanction. They are having legal power. DPSCs have no legal sanction. They are mostly on moral and political considerations. And another major distinction between fundamental rights and DPSC is this. Fundamental rights do not require a separate legislation for its enforceability. That it is there in the Constitution itself makes it enforceable. Whereas DPSC usually requires a separate legislation for its implementation, how it should be done and what it should be done. So DPSCs are not automatically enforced. So some states may adopt, some may not. Central government may bring it. So DPSC requires some additional act from the state to bring DPSC into force, unlike fundamental rights. Usually, the way the courts intervene in fundamental rights, they say that they will declare any law as being unconstitutional and invalid if it infringes fundamental right. Okay. However, the courts cannot declare a law violative of any DPSC as unconstitutional and invalid in case it is challenged as being against DPSC. Right. So, yeah. Fundamental rights are mostly individualistic. Okay, they are personal in character, whereas DPSC they promote the welfare of the community in general. So it is more societal and more socialist. So these are some of the differences between fundamental rights and DPSC. Just to get into some of those. Finally, let's go to just before we go to fundamental duties. Yeah, this is to promote sustainable development. So, Vellore Citizens Welfare Farm case, TN Godavarman case. TN Godavarman case is called the forest case. It tries to bring in forest management in India. The Supreme Court said if the executives cannot manage the forest, we will do it. So, to promote sustainability, to protect the environment for the future generation, the Supreme Court intervened in these two matters. Okay, uh, yeah, that's fine in terms of Article 48A because Article 48A is for protection and improvement of the environment, safeguarding forest and wildlife. Okay, I think it's important now to understand that there are some um, kind of observations of DPSC. Okay, now DPSC, friends, as we all know, does not have any legal force. So, what is the purpose of having it in the constitution? Is one view that is taken very often. Then a lot of people have said that it's a check, but without any signature, right? So it's like having nothing on your hand. So they have like these are people who have said that this is just nothing but a dustbin of sentiments. Yes, that is what has been said by T.T. Krishnamachari. He said it's a dustbin of sentiments. A lot of people have thought that this is important. It's a pious aspiration. A lot of people have said it's a manifesto of aims for the state. So there are two views of the same sign. People have criticized the illogical arrangement of DPSC. Right, there is no chronology or a structure or a hierarchy to how these DPSCs have been written. And interestingly, as I told you, they've never been classified properly, socio-economic or whatever, it's liberal or what. So it's a very structureless chapter, and it does not have any reasons of science or technology. It sometimes is quite prejudicial, and it can vary from different state to different state because India is actually divided by 5 geographical zones. So necessarily DPSC have never taken that into consideration at all. DPSCs have been criticized as not being very aggressive in its objectives and mottos. Though I told you DPSCs have been amended only twice, there is no new fresh impetus infused into DPSC. I think a review of the constitution may actually lead to that. And finally, DPSCs have been criticized because DPSCs may result in a lot of tension in the federal structure of the state itself. Uh, and this has happened quite very often. Now, you will notice the conflicts may be between the president and the government because the government may not want to implement DPSC right now because the implementation of DPSPs are mostly based on the economic capacity of the state and the political will. So I will put economic capacity first and the political will next. So economic capacity means is the state prepared to fund, for example, if you say Manrega or the Mahatma Gandhi Rural Employment Guarantee, which is a law that is in furtherance of the social justice, of DPSC. The state must have that much funds to actually provide the same. Means of livelihood is ensured. Means of guaranteed employment or right to work is ensured through the Manrega project. So because everything is on economic basis and then political basis, it may result in a lot of tension between even the central government and the state government. And very often than not, you will notice that because it's a kind of a very sentimental direction, some prime ministers may actually overrule their cabinet. These are possibilities to implement DPSCs as well. So it may result in a lot of conflict towards the implementation of some of the objectives under the DPSC. I think, I think so. Those are some of the pitfalls on our observations on what DPSC should have been. However, of course, they continue to be as a very important part of the constitution. And I think to some extent they have filled the vacuum in the constitution between fundamental rights and the power of the government. They fill in between that. So in the part 4 is actually between part 3 and part 5. So somehow, before you say what the president can do, what the government can do, you just give them some kind of a document about what vision should be there and what policy should be there. And I think, in one extent, I think one of the justifications of DPSC is it's not just based on political ideologies or parties. Here is a constitutional ideology. So, in that sense, I think it passes the crucial test of establishing a non-partisan kind of constitution, a constitution for the entire country, and not necessarily driven by any particular philosophy, ideology, or any kind of political whims and political fancy. So I think there is some justification to how it is, but of course there is always scope for improving DPSCs and adding new impetus that may fulfill the aspirations of the current generation. For example, there is a lot of debate today on uniform civil code. Maybe the current generation seems to have caught the idea that it is time that the state implements the same, because Article 44 of the Constitution, which speaks about uniform civil code, has never been attempted to be brought about. Though we have some form of uniform civil code in some states, but that is like Goa, for example. It's a Goan Portuguese code. Though not a perfect uniform civil code, it does give you the sense of what that state should aspire to. So, your rights are not dependent upon your religion or to what caste or creed you belong to. Your rights must be protected under the Constitution uniformly. So, Muslim woman or any other woman need not be discriminated just because she is Muslim. So, every right of every gender, every person under the Constitution must have equal protection of rights, especially right to property and right in marriages as well. So, that is the agenda of Uniform Civil Code, and that is being pursued right now as we speak today. So, finally, coming to the fundamental duties, friends, you will notice that we not only have fundamental rights, we have fundamental duties in the Constitution as well. This has been said. And I think the fundamental duties are very, very interesting, because what they say is look, you have a duty towards your community and your country. And these are, you have, as a human being, you ought to be duty conscious. This is a part of your personality. You have responsibilities not only to your family, to your society, to your country. And to that extent, you must follow those fundamental duties that is stated in the Constitution. Fundamental duties were not there in the Constitution, but it was brought in through the amendment, 42nd Amendment to the Constitution in 1976. And they have played a very important role for citizens' participation in the development of the nation. Right? So, what are these fundamental duties? I would like to state that, because if we are all citizens of this country, knowing our fundamental duties in the Constitution is very important for all of us, isn't it? So, there are 11 duties in Part 4A. Okay, this is the fundamental duties. Okay, so let me read all the 11. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. So you have a duty to abide by the Constitution, respect its ideals, its institutions, the national flag and the national anthem. This is a fundamental duty. To cherish and follow the noble ideas which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national service whenever called upon to do so, to promote harmony and the spirit of common brotherhood among all the people of India, irrespective of religion, linguistic, and other sectional diversities, to renounce practice of derogatory, any kind of derogatory to the dignity of women. Oh yes, this is a fundamental duty. To value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion to living creatures, To develop a very scientific temper, humanism, and in the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises higher levels of endeavor and achievement. And finally, the one that was added by the 86th Amendment in 2002, the last one is who is a parent or a guardian, they shall provide opportunity of education to their children, as the case may be, between the age of 6 to 14 years. This is a fundamental duty of parents and guardians. So, these are the 11 duties that are there in the Constitution of India, and every citizen is expected to follow these kinds of duties. In case a citizen is found not following these duties, of course, the courts can decide to enforce these duties as well. So, friends, with this, we should conclude part 4 and part 4A of the Constitution of India. So, we have got into a very elaborate discussion of the Constitution in its early chapters, and this should help you understand how the public administration in India ought to have evolved. You ought to evolve your public administration keeping in lines the constitutional ideals and principles, uh, and to know the rights of citizens, and as a public administrator know the duties towards the citizens as well. This is the dimension of public policy as the constitution states it. Of course, the constitution is only one of those documents that can state that public policy, and there are so many other philosophical ideas and documents and legislations that can also frame or structure the kind of public policy this country ought to have.